All right, hello everyone, and thank you for joining us this morning. My name is Karen Brownlee, and I am the Adult Program Coordinator at the North Suburban YMCA in Northbrook, Illinois. In that role, I bring a variety of programs to adults in our community, including social networking opportunities, donation drives, brain games, and the Adult Education Series, which you are attending today. I'm going to ask everyone to please mute yourselves right now so that we can hear the introduction and so that we can hear Matt. And then if you have questions, you can unmute yourself, and I'll mention it again later on in my introduction. But again, it's my pleasure to welcome you to Estate Planning 101, hosted today by Matt Margolis. Matt is an estate planning and elder law attorney in Park Ridge, Illinois, and works with his partner, Lauren Weldon, to help people protect what they value most. Matt has been with the Adult Education Series since its inception, and I counted this, Matt. He has hosted 40 presentations through the Y. Next month, Matt will have been practicing estate planning and elder law for 10 years. He assists his clients with their estate planning and elder law needs, including special needs, trust administration, decedents' estates, and guardianship. His firm counsels clients from birth to death and ensures that their estate planning documents reflect the different stages of their lives. Matt safeguards clients' legacies by confirming that estate planning documents are appropriately incorporated into their planning goals. His program today will focus on why estate planning is important for everyone, not just the uber wealthy. We will be recording today's session to make it available as a podcast on our Y's website. So if you're a Y member, you'll be able to reference it down the road as well. The Adult Education Series programs typically last an hour, and Matt will take questions both during and at the end of his presentation. If everyone could mute yourselves during the presentation so that background noise doesn't interfere with Matt's talking, you can then unmute yourself when he opens the forum for questions. The Adult Education Series is free and open to the public, but as a nonprofit organization, we all are always happy to receive donations from you. If you enjoy today's programs and would like to support adult programming at the North Suburban YMCA, please feel free to make a donation to our Y, either by going to our website at www.nsymca.org or emailing me. Again, thank you for joining us today, and a special thank you to Matt for your time and for your effort in putting together today's presentation. And now I will let Matt talk to you about why it is important to create an estate plan. Take it away, Matt.
Karen, so formal.
Yeah, did you like that? I checked out your website and everything.
Really good. Yeah, very. Yeah, I'm impressed. I'm impressed. I couldn't have said any of that better myself. Yeah, crazy. Next month will be 10 years doing this.
Yeah.
So, good morning, everybody. Thankfully, we're in February. I keep on telling my wife we are at least halfway through the winter. At least in my head, we are. And with 2 kids under the age of 5, that is very important to be halfway through this winter. So, with nothing to do and nowhere to go. So, as Karen mentioned, my practice, Margolis Weldon is my partner, Lauren and I. We've had the practice. As of last week, we had the practice now for 6 years. I've been in this area of the law, as Karen mentioned, for just about 10 years. Focusing solely on estate planning and elder law. That's all we do. Yeah, Karen pretty much covered a lot of what we do, so I don't really need to say a whole lot more. Other than we'll get started. My presentation style is very conversational. I'm not going to share my screen. Not going to show you any graphs. If there's any information that you'd like following the presentation, feel free to email Karen or myself. I put my email in the chat box. I do sort of have an outline that I can send out after the fact. I don't like to give anything ahead of time. I'd rather you just kind of stay present with me and take in the information, but I do have an outline that I can send that would have some information for you. So whether you take notes or not, feel free to shoot me an email and I'm happy to pass that along. Today's presentation is a presentation that I give very often. I probably give it, I don't know, I give it anywhere from 2 to 7 times a week, let's say. This estate planning 101 talk is literally the information I give any individual or couple that wants to meet with me to discuss doing some estate planning themselves. So all the information today that I'm giving you guys is exactly what you would get if you were sitting down with me as a prospective client to do some estate planning work. I've also been doing this talk via Zoom once a month since April, in the evening on a Thursday night, the last Thursday of the month. So if anybody knows anybody that might have any interest in this topic after, feel free to give them my information. They can always contact me and I can invite them to one of our evening Zoom talks. The next one, I think, being February 25th in the evening. So what I would ask is, and I appreciate everybody muted themselves. If anybody has a question, I'm happy to take questions throughout the presentation. If you guys are like me, I don't want you to have to wait. You'll probably forget your question 2 minutes after. So if you're showing your screen, if I can see your face, if you can kind of give me like a raised hand, I think there's like an actual way to do it, but we'll just do it the old-fashioned way and we'll raise our hands. So yeah, the duck can raise the hand. There you go. If you have a question, raise your hand. I might just give you one of these, and that just means that I want to finish my train of thought, because I will forget where I'm going if I sort of stop in the middle of what I'm talking about. And the last thing I'm going to say, last housekeeping rule, I'd really like the questions to be kept very general. So if it's a sort of a general question clarifying something I'm asking, great. I really would prefer not to answer any questions that relate to somebody's very personal issue or their mom or their dad. Any kind of question that kind of comes from there. Inevitably, even though I say this, those questions come up, and I probably answer them. But I tend to be a little snippy and say, hey, we talked about this. So those questions you can always reach out to me after the fact. Okay, that's why my contact information's here. I'm not trying to hide from anybody after the presentation. I'm around, you can find me. All right, let's get started. Let's jump in. So estate planning 101. When we talk about estate planning, we're really looking at two different avenues of planning for the most part, okay? We're not gonna get into any crazy detail today. We're not talking about all the different, charitable remainder trusts we can create and the irrevocable life insurance trusts we can create. If we have lots of money and we need to protect our assets and not pay any estate taxes to the state of Illinois, or that we want to leave money to charities in a way where the money doesn't affect us from a tax standpoint. Today's really more general. Today's really more for, what I'm going to say is like the 99% of us that need to do some planning, right? And so for most of us, when we look at doing any kind of planning, again, we kind of look at this idea of a will or a trust. And I would say most people kind of come from the place of, oh, I just need a simple will, right? I love this comment. I get it all the time in my office. Somebody calls me and they say, Matt, I just need a simple will. And my response typically is, I don't know what that is. I have no idea what that is. You'd have to enlighten me as to what a simple will is. Maybe Staples. Staples might sell simple wills that you can pay $10 for and fill in blanks. LegalZoom online that you pay $50 for. That might be a simple will, right? Where you fill in the boxes and then it spits out a will for you. While we might have situations that are not complicated, I would say that most attorneys that that concentrate their practice in estate planning or elder law probably don't have simple wills, because our goal is to protect people, right? We want to make sure that the wills have all this language that confuses our clients as much as possible. And then we just basically tell them, you need it in there, right? You need to make sure that you're protected, because all these crazy things could happen. And even though they will likely not happen, we want to make sure that you're protected, okay? And so in that sense, there aren't too many truly simple wills out there. So when we look at a will and what a will actually does, right? Because let's start with this document that people have ingrained in our heads over the course of our lifetime that we need to have. For most of us, it started when we had our first child, right? Everybody's like, you need to have a will, right? If nothing else, who's going to be the guardian for your minor children? And so in its really basic form, a will is like a letter to a judge. Okay? Dear Judge, my name's Matt Margolis. If you're reading this, I'm dead, and this is what I want to have happen, right? And I'm sorry, guys, but what we're talking about today deals with death, right? Let's be realistic. If we were going to live forever, we wouldn't have to draft a will, okay? And so we have this will, and it really acts as like a letter to the judge. Dear Judge, my name's Matt, I passed away, and this is what I want to have happen. If my wife survives me, she will be the executor of my estate, right? And the executor of my estate is who's going to manage things, who's going to make sure that all of my final expenses are paid, that my final tax return is dealt with, that my house is sold, that any interest I have in any other real estate is dealt with. And then at the end of the day, everything is distributed in the way that I want it to be distributed. So my wife would be the executor, and she'd also be my sole beneficiary, right? And when I die, if she survives me, everything goes to her. But what if my wife doesn't survive me? Well, Then I'm going to have my brother be my executor, right? Now my brother's going to manage my estate. And let me be clear, the executor likely isn't just going to the courtroom, bringing the will up to the judge and saying, hey, what do I do, right? The executor is going to hire a lawyer like me, fill out all the paperwork, and then the lawyer is going to deal with all the stuff in court, right? The executor pretty much never, ever needs to go into court unless we have a contested estate and people are fighting. And that's another story. We're not going to talk about that today, right? So the executor hires a lawyer, the lawyer deals with the process, and then basically tells the executor along the way what the executor has to do to make sure the estate gets settled appropriately, right? So if my wife doesn't survive me, my brother's the executor, and everything goes to my 2 kids at equal shares. Great, right? Pretty simple. Here's the reason why we go through probate, even though we have a will, right? Because a lot of people, when I say, typically with a will, you're going to go through probate, they kind of give me this puzzled look, right? Like, what's up with that? I thought I was creating a will to not go through probate. Well, here's the reason why people go through probate, all right? And with a will or without a will. The reason why somebody goes through probate is when they own assets in their name only that don't have a beneficiary on them when they die, right? So let's just say I own a brokerage account at UBS, my name only. It's not a joint account with my wife. My wife predeceased me. Maybe it was joint at one point, but now it's in my name only, and there's no beneficiaries listed on the account. If it's over $100,000, or if the totality of the assets in my name are over $100,000 with no beneficiaries and no joint ownership, they will go through probate, even with a will. The only difference is that the will direct where they go and who they should go to. Without a will, basically it's the rules of the state of Illinois that will decide where my stuff goes. Now, the default rules of Illinois for somebody that's married and has kids. So if I never put a will together, I die tomorrow, I have assets that go through probate. Half of my estate goes to my wife, half goes to my kids. I can tell you, most of us that are married would probably say everything would go to our wife or our spouse. We wouldn't be giving half to our spouse, half to our kids, right? Typically we say, okay, when I die, everything goes to my spouse. If she doesn't survive me, then it goes to my kids, right? So there's sort of this default plan in place that the state of Illinois has created for a lot of us, right? It's a free plan. We didn't need to pay an attorney for it. But this is what it is, right? It's a one size fits all plan. So that's why we go through probate. It's when we own assets in our name only with no beneficiaries. So I'm going to back up for a second. With a lot of married couples get away with no probate, no plan. They did no planning at all, right? They never did any planning. The first spouse dies. A lot of married couples get away with no probate for that spouse that died. Why? Because they owned everything jointly, and anything that they didn't own jointly, they were beneficiaries for one another, right? They own their house in joint tenancy or as tenancy by the entirety. They own the bank accounts in joint tenancy. They own the investment accounts in joint tenancy. And then the life insurance and the 401ks and the IRAs, while those were assets they could only own individually, they had their spouse as beneficiary. And so literally my will could say everything goes to this wonderful lady, Christy, who I love is nodding her head and like agreeing with everything I'm saying. It's making me feel, it's very validating. So I appreciate that. But I could say everything goes to Christy, and the reality is nothing would go to Christy because my wife is a joint owner and my wife is beneficiary on these accounts. All of that trumps whatever my will says. Okay. And if I have no will, again, same thing, no probate, everything goes to my wife just because of how I own it. Now, my disclaimer, I am definitely not suggesting that anybody that's married on this call doesn't plan because they're married and they have this default plan in place. So by no means am I telling you not to plan. I'm just telling you people can get away with it. But inevitably, what happens then is that widow or widower, right? Or that, lifelong bachelor, or this is such an old school term, but I hear people saying it still, or the spinster, they have assets now in their name only. And honestly, adding, my niece or my nephew, because people always say this, right? What if I just name my niece or my nephew as a joint owner of my account? Or I'm going to name my brother or my sister as a joint owner of my account. There's a difference between avoiding probate, which is what I would be doing by adding these people on my accounts or adding these people on my, the title of my house, versus proper planning. right? So I can avoid probate by having Christy as a joint owner on my bank accounts and adding her on the title of my house. But that's probably not the best plan, because what if Christy's married and Christy gets a divorce? Christy's joint on all of my assets. Those are as much hers as they are mine. What if Christy gets in a car accident and hits somebody and she's underinsured and somebody sues Christy? Guess what? They can go after my stuff. Okay. Some of these things I'm saying might be far-fetched. I get it. But the reality is they can happen. And so, yeah, we saved some money by just adding somebody as joint on the account, and we kind of cut some corners. But I think the saying is, was it penny wise, pound foolish, or vice versa, whatever it is, you know the saying I'm talking about. This is our estate, right? And I don't care if your estate is $50,000 or $3 million. It's probably not worth it to take these types of risks, right? And so that's why it's just important to plan and do proper planning. In general, probate is not the end of the world, but probate is also not just like I'm in and out of court and we're done type of process, right? The average probate estate that we deal with, and we don't take on the crazy ones. And what I mean by that is we don't take on the ones that get a little messy, right? It's like the simple divorce versus the messy divorce. We like the simple probate cases. Somebody passed away, the family gets along, there might be assets all over the place, but we get through it, and we're probably looking at, on average, typically anywhere from a 1 year to 2 year time frame. A lot of times, probably closer to 12 to 18 months. But figure a year to 2 years from start to finish, probably somewhere between $5,000 and $10,000 of attorney's fees and court costs from start to finish. Now, again, that's what we see because we take on the simple ones. There are more complicated estates. There might be 3 or 4 pieces of real estate out there. There might be kids that don't get along. And then other attorneys kind of get involved in the mix. Well, those cases can then take multiple years and can cost tens of thousands of dollars in attorney's fees, right? Again, it's like the messy divorce. Who wins in a messy divorce? The attorneys, not the clients, right? I was talking to an attorney friend of mine the other day that deals in family law, and he said that these clients spent probably $500 to $700, not 100,000, $500 to $700 arguing about how to split up the stimulus check of $600, right? Crazy. We're spending more money fighting about spending more money fighting about less money. So just trying to give you guys an idea of what the probate process, how long it can take, what it can cost. And let's just be realistic. Nobody is dealing with probate saying, God, I love this. This is really great. I love working with a lawyer and having to deal with all this paperwork and, paying all these extra fees that we probably could have avoided if we planned in another way, right? We try to make the process easy for people, and we hope people don't, dislike us. But listen, the reality is everybody would rather not. There's nobody that I meet with that would say, I love probate. I would love to go through probate again for my, I love my kids to deal with this after just dealing with this for my mom or dad. Right. So the one thing I want to be clear about, which I think I was, but I just want to clarify, is the assets that will always avoid probate will always be those that have beneficiary designations. Okay, I just want to be clear about that. I think I mentioned that, but anything with a beneficiary designation will always avoid probate, and anything owned jointly obviously will avoid probate as well. So how do we avoid probate? Well, the majority of people that are going to avoid probate are going to probably put what's called a revocable living trust in place. This is going to be the most common planning tool used to avoid probate. And the idea behind the revocable living trust is it's sort of a centralized bucket, if you will, that I can put all of my assets in during my lifetime. And this bucket has this wonderful probate protection encased around it to ensure that I don't go through probate. But it doesn't come without some cracks in it, okay? And here's what I mean, right? So a client comes to us and we put together this revocable living trust, and the trust operates off their social security number, okay? Just so the trust, it operates off, let's talk about me, right? It operates off my social, so nothing changes with my life. I still file my taxes the same way. Nothing changes significantly. And I've got the Matt Margolis trust. It's on my social security number. And the way that I'm going to avoid probate is that I have to retitle my assets to the trust. And this is where people slip through the cracks, and I'll explain that in a minute. So I have to retitle my assets to the trust. So typically, the estate planning attorney that we work with will handle any real estate. So any real estate that I own, typically my estate planning attorney is going to help me put together a quitclaim deed, record it with Cook County, Lake County, whatever county I live in. And we're going to transfer ownership of the house from Matt Margolis individually to the Matt Margolis trust. And if I'm married, I can have the Matt and wife trust, right? We can have a joint trust for the two of us. Okay, so we transfer the house to the trust. Any real estate in other states, typically that attorney can make contacts with attorneys in other states, and they can and then those attorneys can draft a deed for the Michigan house to go into the trust, or for the Florida house to go into the trust. And it's totally fine for a piece of property in another state to go into a trust that we created here in Illinois. No issues, okay? So we retitle the real estate first. Well, now we have to think about all the other assets, right? The check. And people always say, well, even my checking accounts? Yes, your checking accounts, checking, savings, money market, CDs, brokerage accounts, stocks, investments. All of those accounts need to be retitled to the trust as well. Then there's certain accounts that have to stay in our name, typically. IRAs, 401ks, right? Any kind of retirement account that has to be owned by an individual. And so again, because we have beneficiaries built into IRAs and 401ks, we don't have a need to put them in the trust, but those are assets that we just want to make sure that our beneficiary designations are up to date. Because while they should never go through probate, I can tell you right now, we are dealing with a probate estate for a client who, my disclaimer, we did not do their plan. This guy's planning 15 years ago. But he had a life insurance. The reason why we're going through probate is because he had a life insurance policy that he owned with his wife as the sole beneficiary. He has 4 children. The 4 children were never named as contingent beneficiaries on this life insurance policy. His wife died 10 years before he died. Do you want to guess that he never updated the beneficiaries on that life insurance policy? And so for something that should have never gone through probate in the first place, we're opening up a probate estate for a life insurance policy. So we want to make sure our beneficiary designations are up to date on life insurance policies and 401ks and IRAs. And if you've gone through a divorce, even more of a reason to make sure you look at these policies and the beneficiaries, because so many people still leave their ex-spouses as the beneficiaries. Guess what? You die, your ex-spouse is still the beneficiary. Good luck with your new spouse or your children trying to make a petition to the life insurance company that it shouldn't go to the ex-spouse. Okay. In some cases, what we'll do is we'll name the trust as a beneficiary of a life insurance policy or a 401k or an IRA. It all depends. Okay. It's typically with married couples, we still name the spouse as the primary beneficiary on these assets. But in a lot of cases, we might name the trust as a contingent if we have minor children, right? Or if the beneficiaries after our spouse are minors or younger, because we might not want them. Something happened, if my wife didn't survive me and then I passed away and my kids were, 14 and 17, I wouldn't want them to inherit my $1 million life insurance policy, right? I wouldn't want them walking around with that kind of money at 18, right? Because at 18, that would be the default as to when they're adults and when they'd have that money. And so that's why we would name the trust. And I'll get into, when we start talking about the trust in more detail, you'll understand why I'm suggesting that we would maybe name the trust as a contingent beneficiary. So the reason why I say that the trust isn't without cracks is because we as people are not perfect, right? We all know that. Our spouses know that, especially about us. So what happens is we've got this trust, and the trust is going to help me avoid probate. And that's why I went to the lawyer, right? It's not because I'm the Pritzkers and I've got millions and millions of dollars that I need to protect and not pay the state of Illinois any estate taxes. It's because I want to make sure that my estate doesn't go through probate. Okay. And so what happens is people still go through probate when they have a trust. And here's why. The reason why is because I work with clients, and while we retitle all the real estate, all I can do is have a discussion with them about all of their other assets and say, all right, listen, John and Jane, you guys have, they list out all of their accounts for me. We go through it in detail and we talk about it. Okay, this account you guys need to retitle to the trust. This one you need to update the beneficiaries of. This one needs to be retitled to the trust, etc. Well, short of holding their hand and walking into Bank of America with them and sitting down with their financial advisor with them, I can't guarantee that they are actually going to take my advice and retitle their accounts into the trust. All I can say is this is guide them as to this is what you should be doing. And if there's questions along the way, call me and let me know if you're having any problems. And I do say, listen, if you want me to go to Bank of America with you, you can pay me extra and I'm happy to go take a trip to the bank with you. But most people don't want to pay me to do that. And they don't need to, okay? Bankers are very familiar with the idea of retitling assets into trust. There are very few financial institutions out there. I would argue there's no financial institution out there that any client of mine is going to go to, and they're going to be a case of first impression. Oh, a trust? What's that? Oh, I've never heard of that. Let me go get my manager. And everybody else down the line's never heard of a trust before, right? It's just not reality. So these are things that, listen, it's like ripping off a Band-Aid. Just go get it done and be done with it. And then you don't need to worry about it, right? Because inevitably I have clients that reach out to me a year later and I bring this up with them and they're like, oh yeah, we still haven't done it yet. And I'm like, I don't know what you're waiting for, And unfortunately, this is why we have clients sign off on what we call these funding instructions. And it's basically a CYA. I don't know if anybody knows what CYA stands for. It doesn't stand for cover your butt. And so the reason why we have clients sign it is because it's unfortunate that we basically have to be like, listen, you're signing this, understanding that retitling your assets into the trust is your responsibility and it's not ours. Why do we have them sign it? Well, because, adult children, when their parents pass away who had trusts, what do? Now we're going to go through probate. Let's go attack the lawyer who did the planning and, put a trust together for my mom and dad and didn't tell them that they needed to put all their stuff in the trust, right? It's unfortunate. That's the world we live in. So we have to cover our butts. Again, these things shouldn't happen, but they do. And so because we know that these things can happen, every time we create a trust, we create what's called a pour over will. Like a pour over coffee, a pour over will. Okay, now this is really a simple will. I'll kind of put this in the simple will category, but it only accompanies a trust, right? It's like a sidecar to a motorcycle, right? And the reason why the pour over will is simple, it really does, if you have minor children, it does three things. If you don't have minor children, you're really only concerned with two aspects of it. Basically, the will, you're going to name executors, right? And the executors of my will are who's going to carry out the estate in court if something goes through probate. If we have minor children, the will is always the place where we name guardians. You cannot name guardians for minor children in a trust. You have to name guardians in a will. So if those of us that have minor children, we name guardians for our minor children in the will. And then the last thing, the pour over aspect of the will, is that my will basically says, hey, judge, the beneficiary of my will for probate purposes is the Matt Margolis Trust. And so at the end of the probate process, okay, it does not make probate any shorter. It's still going to take the same amount of time that it would whether I had a trust or not. But at the end of this probate process, whatever is going through probate is going to pour over into the Matt Margolis Trust, and then the trust will distribute it according to its terms. Okay, because the trust is going to have all the meat and potatoes of where my stuff goes and who gets it and how they get it and all of that fun stuff. Okay, let's look at the pour over will as a safety net, right? It's like the safety net underneath that person on the trapeze, right? We hope we never have to use it, but it's there in case we need it. Okay, so I always tell clients, we're putting the pour over will together. We explained it multiple times. Let's just hope we never use this, right? So I just saw a question in the chat box, which I'll comment on briefly. And Paul, I know you just joined us, but if you could put yourself on mute just to prevent any background noise, I'd appreciate it. So Matt, did you say an IRA and 401k can be out into a trust? So an IRA and 401k, you can name a trust as beneficiary of an IRA and 401k. Yes. So it cannot be put into a trust. I cannot retitle my IRA or 401k to a trust. During my lifetime, the IRA or 401k has to stay in my name, but I can make the trust a beneficiary. And again, I'm not going to go into all the details of that. There are some benefits of it when we have minor children and we want the money to go to them through the trust, which we're going to get to in a minute. But there are also some drawbacks. There's some additional tax consequences in certain instances by naming a trust. And so it's not, again, there's some counseling that goes along with naming a trust as beneficiary. It's definitely not something we do every time, and it's not something that we don't do every time. So, okay, so we have the trust, we have the pour over will. So with my trust, I'm what's called the trust maker of my trust, right? I am the one creating it. I'm the one making it, right? It's exactly what it sounds like, trust maker. I'm making the trust. It's my stuff that's going to go in the trust. My wife and I, or my spouse and I, can be co-trustees or co-trust makers, or joint trust makers. We're the ones creating the trust together. It's our stuff going into the trust together. Okay. Then we can be, as trust makers, we can make changes to the trust over time, right? So things in our life change. Well, we want to make a change, right? Maybe we don't want to leave money to this person. Maybe we don't want to leave, my grandfather's watch to my son-in-law, whatever it is, right? So we can amend the trust as time goes on, as long as we have capacity. If we lose capacity, no more amendments, right? Then we're the trustees. The trustees of the trust are who can access what's in the trust at any given time. So my wife and I are the co-trustees, right? And being co-trustees of a trust, or the trustee of a trust, it's like when I had access to a bank account before, or it's like being joint on a bank account, right? Now that I'm retitling all my bank accounts and investments in my real estate to the trust as a trustee, now I can still deal with all of those things, just like I did before I had a trust. And nothing changes, right? Again, it operates off my social security number. My life goes on the same way. What I tell clients is the only change you're going to notice is that when you get your bank statements in the mail or emailed to you, rather than saying Matt Margolis, Christina Margolis, and then our address, it's going to say the Margolis Trust, Matt Margolis trustee, Christina Margolis trustee, and then our address. That's it. Literally the only difference you will see. Now, the only thing I'm going to say here, and I'm going to talk about it for like 3 minutes, and that's it, is, in some cases, we use a joint trust for a married couple, and in some cases, we use two trusts. And the reasons why we would use two trusts might be, it's a second or third marriage, it's a blended family, the couple has always maintained separate assets, and their goal is that, hey, listen, when I die, I want my assets to go to my kids. When you die, your assets are going to go to your kids. Maybe we maintain a joint account, just to pay our household expenses, and that's going to go to the survivor of us. But otherwise, we each keep our own trust for that reason, right? We love each other, we're married, but hey, listen, we got married later in life. We want to make sure that each of our kids are provided for. And, if I die early, I'm not leaving all my money to my wife for her to then spend and then maybe leave to her kids. My kids get nothing. So that would be a situation where we do two trusts. And the other one, which would be probably more common, is where we have a taxable estate. So in Illinois, we have a taxable estate if we have over $4 million. Okay, so we each get a $4 million coupon, we'll call it, over the course of our lifetime and at our passing, to pass on tax-free. Okay, so at my death, I can pass on $4 million to my beneficiaries without any estate taxes being paid to the state of Illinois. And there's no inheritance tax in Illinois, right? All it is it's a state tax, meaning if there were any taxes, they get taken off first, and then the money gets distributed to the beneficiaries. It's not like they inherit the money and then they pay taxes on it. So if my wife and I have an estate, this really applies to married couples. If my wife and I have an estate that's over $4 million, it's typically going to make sense for us to do two trusts. And the idea, again, I want to be really brief about this, is that we're going to try to divide the estate 50-50, right? We got a $5 million estate. We want to try to keep it as, 2 million in her trust, 3 in mine, or 2.5, 2.5. The idea behind it is that we would still be, even though we'd have the Matt trust and the Christina trust, and her trust operates off her social, and mine operates off my social, we would still be co-trustees of each trust. Because that way, even though, now we might be taking all of the Chase accounts and putting it in her trust. Well, I don't want to lose access to those accounts just because we have to split up our accounts for tax purposes. So we're still going to be co-trustees of each trust. So we still have joint access to everything. But the way it works is that upon my passing, my wife would be the trustee. She would still have access to the money for her benefit, but my trust gets a taxpayer ID number. And the money in my trust never becomes part of her estate for tax purposes. So that upon her passing, she's only passing on what's in her trust. And so if it's under 4 million, no taxes. And then my estate was in my trust, and that stays as my estate and doesn't get commingled with hers. So that's all I'm going to say on that. But that's typically why we would look at doing 2 trusts versus 1 trust. There's some estate planning attorneys that will always default to 2 trusts with a married couple. That's fine. It's sort of 50-50 in the estate planning world. That's not how we do it in our office. Our default typically with married couples is a joint trust, and then we'll go to the 2 trust model depending on if there's other circumstances involved that would benefit, where the couple would benefit from 2 trusts versus 1. And our thought is just we want to try to make things, we think 1 trust is a little more simple, and we don't want to make it more complicated for people unless we really feel like there's a benefit to them to do that. With it being their choice at the end, right? I'm working with clients right now where I gave them the option of 1 or 2. I actually think that 2 would benefit them because they're on track to probably have a $4.5 to $5.5 million estate by the time they both retire in the next 5 to 6 years. But they opted for a joint trust, in which case, of course, I then have them sign a contract with a disclaimer saying, you likely have a taxable estate. You chose to do 1 trust anyway. You will likely have estate taxes, just so you know that, right? Again, back to our world of disclaimers and making sure that we're all covering our butts so that future generations don't sue us. So we have the trust. My wife and I are, whether we've got 1 trust or 2 trusts, we're the co-trustees. Well, at some point, I might get dementia. And at some point, I know that I'm going to pass away. And my wife and I will both pass away. And so we need successor trustees of our trust. Because either if 1 or both of us is alive but incapacitated, or then for sure upon our passing, we need somebody to step in as a trustee to manage our stuff, right? If I'm dead and my wife's alive but is incapacitated, we need a successor trustee to step in and manage all of the assets in the trust for my wife's benefit, right? We need that trustee to step in and be able to pay bills and deal with the financial advisor and deal with, selling the house or whatever needs to be done. And similarly, when we pass away, we need to make sure that somebody can step in and manage all of these things and take care of our estate and make sure that, final expenses are being paid, the house is being cleaned up and sold. And at the end of the day, the money's being distributed to the beneficiaries. So when we name successor trustees, we can name people 1 at a time in a particular order, right? My dad, my father-in-law, my brother, my sister, or we can name people as co-trustees, just like my wife and I were, right? Oh, maybe my dad and my father-in-law would be good as co-trustees. They can divide and conquer. Not all of the responsibility will fall on one of them, right? They can each sort of help each other out along the way. Every situation is different. I don't love the idea of there being more than 2 co-trustees, even though I've had clients very adamant about it. And of course, it's their choice, but I'm not shy with my 2 cents, right? Because we've all heard the phrase, too many cooks in the kitchen. Right. So, we can imagine, we've got 4 kids, all 4 kids are going to be named as co-trustees. I just think it's a recipe for disaster, even if they all get along. Okay. Because the reality is at death and divorce, people get weird. That's just how it is. Okay. Unfortunately. So we can name successor trustees, right? That are going to step in and manage things. And typically our successor trustees of our trust are probably going to match up with those executors that we name in our pour over will, right? We're probably thinking of the same person, right? Who's going to administer our estate. So those orders of people, those lists of people will probably match up. So then we talk about beneficiaries, right? Well, when we're gone, who gets our stuff? Oh, those of us with kids, typically it's a little bit easier, right? Because a lot of us just say, oh, we've got 2 kids, goes to our 2 kids 50-50. For those people that don't have kids, it ends up being a much more difficult conversation, right? Does it go to are we going to leave it? Are we going to leave it to our siblings, to our parents, to our nieces and nephews, to charity, to some combination thereof? So whoever we're leaving it to, and I'm just going to use the example of individuals, right? Whether it's children or somebody else, I'm going to say children, but obviously, fill in the blanks to make it make sense for you. When we leave money to a charity, typically we're going to say, listen, we're going to leave them, 10%, I'm going to leave this charity 10% of the estate, and they can use it for their general charitable purposes, right? We're not going to direct exactly how they use the money. Some of us might, but then I tell those clients, you've got to talk to the charity ahead of time and confirm that you're leaving them enough money where they can do with it what you want them to do, right? The last thing I want clients to do is think they're leaving money to, some charity to be used for this specific purpose, but it's nowhere near enough that they would need for that, right? Or, they want like some kind of memorial set up for them, or some kind of, they want their name on a bench in the parking lot of the building or whatever it is, right? you just got to do your research. It's fine. That might be totally fine. But let's do our research first to make sure that what you're wanting is going to be accomplished, rather than you just telling me and me saying, yeah, okay, fine, I'll just write it in there, without saying, listen, you should probably go look into this because that may not happen. So when we leave money to individuals, we can leave it to them in two ways. It can be an outright distribution, meaning let's just say there's $1 million at the end of all, at the end of the day, after all expenses and taxes, et cetera, are paid, there's $1 million. I've got 2 kids. The trustee writes them each a check for $500,000, and they can do whatever they want. Great, that might work in a lot of cases. But then there's some cases where we have beneficiaries that are younger, or beneficiaries that are not responsible, or beneficiaries that might have certain addictions. And leaving any of these individuals' money in an outright fashion might be detrimental to themselves, right? For a number of reasons, right? Immaturity, irresponsibility, irresponsibility, and addiction. So what we do is we leave them the money in trust. Now, this isn't a separate trust that we're creating, right? It's not like I'm telling my clients, oh, looks like we got to create 2 more trusts, guys. That's going to be another $5,000. It's a trust that sort of springs out of my trust, right? So now I've got the Matt Margolis trust. And then when I pass away, I've got the Matt Margolis trust for the benefit of child number 1 and the Matt Margolis trust for the benefit of child number 2. Okay. And my trustee, let's just say it's my brother, he's going to manage the money for them. Typically, we put some sort of parameters on this trust, right? So my wife and I, our trust says that if we pass away and our kids have not yet turned 30 years old, then the money is going to sit in trust for them until they're 30. Now, that doesn't mean that the money can't be used for them until they're 30. My brother's the trustee. He can use the money for their education, their health care, and then anything else at his discretion. They want to buy a car, great. His discretion though, right? Our son says, hey, Uncle Mike, I really like this new, Mercedes AMG. It's pretty sweet. It's only $95,000. And my brother says, you know what? That used Toyota Camry sounds great. Perfect. Let's go look at it, right? So the trustee has the discretion to decide how the money is going to be spent. Okay, and the goal is that we're naming trustees that probably share similar values to us and are going to treat our beneficiaries the way that we'd want them to be treated. Tough love. We can name banks or trust companies as trustees, right? Maybe we don't have anybody that's really close to us that we would trust being the trustee of our trust. Well, there are banks and trust companies out there that we could name. Just so we understand, if we go in that direction, there's fees that have to be paid. They're not extraordinary fees. A lot of times the fees that these professional trustees charge are not that much greater than what we pay a Wells Fargo or UBS financial advisor to manage our assets, right? A lot of these professional trustees charge around 1%, give or take, on an annual basis of the assets that are being invested. But in addition to that, they're actually providing trustee services as well. So in a lot of cases, it's not a terrible deal. But again, we need to make sure that we're talking to those professional trustees and understanding how they charge and what they charge for ahead of time. And so anytime that's something that comes up with our clients, we always say, listen, I'm not giving you that information. You've got to call them. Here are a couple places to call that we like, but you need to hear it from them. You need to understand how they work. And so in our case, if our kids aren't 30 yet, the money goes into trust and the trustee can use it for their benefit until they're 30. If they're over the age of 30 when we die, which I hope they are, then it's an outright distribution. Then whatever, then that $1 million goes, they each get a check for $500,000. They can do whatever they want. And we can set this up in any sort of way. There's some clients that say, we want to leave a third of the estate to our kids when they turn 25, a third when they turn 30, and the remainder at 35. Or I've got some clients that are like, hey, my kids are in their 20s and they are totally irresponsible. They can have it when they're 45 years old, right? For my kids, by 45, whether they're still irresponsible or not, they can have it. We don't need to put any, we're not going to control. We kind of use the term control from the grave. We're not going to control from the grave any further than that. When we name beneficiaries, we also have to consider the fact, we don't love to think about this, what if they pass away before us, right? We hope that they don't, especially if we're naming our children. But what if something happens to one of them before us? Well, a lot of times we'll put default provisions in there to say, well, my son doesn't survive me and he has children, his share would go to his children. If my daughter didn't survive me, her share would go to her children. And if my son didn't survive me and he didn't have children, then everything goes to our daughter and vice versa. So we want to take into account that things can happen while we don't want them to. We want to make sure we've got a plan for it. And then we have something that, I kind of refer to as the Armageddon provision. If Armageddon happened to my family only, where would everything go? Right? So something happened to my wife and I and our 2 kids and we had no grandkids. Now where does everything go? Does it go to our parents? Does it go to our siblings? Go to our nieces and nephews? Does it go to charity? I can say that after reviewing estate plans from clients that come in that have worked with other attorneys in the past, I feel like this conversation almost never happens, because the default provisions that I typically see in documents are basically just say, well, in this case, if that happened, half the estate goes to the husband's, or spouse number one's heirs at law, and half of the estate goes to spouse number two's heirs at law, basically just meaning half of the estate would go to the closest relatives of mine, and half our estate would go to the closest relatives of my wife's. I only have one wife. So that might be fine for some people, and maybe that's what my clients end up choosing, but I want to make sure we have a conversation about it. I want to make sure that there's some thought put into it. The reality is a lot of us have worked really hard for what we have. And, I'd want to make sure that no matter what happened, even if it's crazy and our 5 kids and our 15 grandchildren didn't survive us, I want to make sure that the money's going to go to somebody that those clients care about, or something that those clients care about. All right. I wish I had like a smooth transition. That's really the trust in the will in a nutshell. I want to talk about a couple other documents and hopefully leave a couple minutes for some questions, because I really do have a hard stop at 10:15 today. So anytime we're doing any planning, and this would go for most estate planning attorneys, I think most of our colleagues are in the same boat as us. Anytime we're doing any kind of planning, whether we're putting a will together or a trust with pour over wills, we're going to include a few other documents. Okay, that's going to be a power of attorney for healthcare, a power of attorney for property, a HIPAA, and a living will. A power of attorney for healthcare is a legal document where we are naming somebody to make medical decisions for us in the event that we cannot make our own. We can name as many people as we want, but it is one person at a time. Okay, so unlike the will, where we're naming executors, and the trust, where we're naming trustees, and we can name co-trustees and co-executors, with a power of attorney for healthcare, we can only name one person at a time, but we can name a bunch of people in order, right? So my wife is my healthcare power of attorney. If something happens to her, it's my mom. If she can't do it, it's my dad. If he can't do it, it's my brother, and so on. If I've got 5 people that I really trust, great, let's name all 5. Sometimes it's a struggle to name one, right? I meet with a lot of people where naming one person can be difficult. People always ask, how many should I have? As many as you trust. The more the merrier, with the exception of, just naming Joe the neighbor because he's a nice guy and he mows your lawn when you're out of town. If there's people that are close to you that you trust, great. There's no harm in naming more people, because guess what? I can talk to 5 people today and they could all be really comfortable making medical decisions for me and say, Matt, that's fine. I'm happy to have you put me on the document, which again is something we should be doing. We shouldn't just be naming people and not telling them. We should be telling them and making sure they're comfortable and letting them know how we feel about our wishes, right? I don't want my life artificially prolonged, or keep me alive forever, no matter what, no matter how terrible my quality of life is. Keep me alive, hook me up to machines, freeze me, give me experimental drugs. Fine, to each our own, to each their own. But make sure that you're talking to the people that you're going to name and that they know how you feel and what you want, because it's just as beneficial to know that somebody's not interested in making decisions for you as it is knowing that they are. And I say that we should have a conversation. Here's the thing: in the healthcare power of attorney, I get to check a box, right? It's such a perfect document. I get to check a box that says I value the quality of my life, or I value the quantity of my life, and it goes into a little more detail than that, of course. And obviously, I'm being a little sarcastic. It's not a perfect document, okay? And we realize that, and that's why we tell people you have to talk to people you're naming, because the last thing I want is for a situation to arise where a really serious decision has to be made, and your son or daughter, who you never had this conversation with, is literally looking at a piece of paper where you checked a box and they never heard you tell them, this is how I feel, this is what I want. I don't expect you to do it in the middle of a holiday meal. And I don't expect you to literally think of every single situation in the world that could occur and what you'd want them to do in that situation. Right? I always talk about the Seinfeld episode. If anybody's a Seinfeld fan out there was a Seinfeld episode, of course, back in the day, like every Seinfeld episode, where Kramer's sitting down with Ben Stein, who's portraying his attorney, and he's sitting there with Elaine. And basically, the attorney is going through all of these different situations about Kramer having a pretty terrible medical situation arising, right? You can breathe on your own, but you can't move your arms or your legs, or all these weird things, right? And it's obviously supposed to be funny. And Elaine is sitting there next to Kramer saying, "Oh, pull the plug," or "I think I'd want to keep you alive if that happened," right? I think that sounds good. And so clearly, Joan, I know you just joined us. If you can mute your mute yourself, it's a little background noise. That's okay. And so I always bring this up because the reality is there's no way we're going to think of every single crazy situation that could happen to us. So we're not going to go down that path. But we need to have some sort of conversation that's at least sort of like, you know what? Listen, I value the quality of my life. I want to make sure, I'd obviously want you to do what you can to keep me alive. But if the doctors are saying that the chances are so slim that I'm going to recover from this and have any kind of meaningful life, don't just string me along, right? Don't just hook me up to machines to keep me going. I know it'll be hard, but I need you to just let me go, right? That's what I want. Or again, the opposite, do whatever you can to keep me alive, right? So we want to make sure that we're talking to people about it, and the people that we're naming, so that they heard it from us. So that, again, I can just assume, because I've never been in this situation, I can just assume that it would be a little bit easier if we have that conversation. The property power of attorney is the other power of attorney we have in Illinois. This is where a legal document where we are naming somebody to make all decisions for us that are not healthcare related. Who can deal with my IRA or my 401k if I'm incapacitated? Who can deal with my life insurance policy? Who can deal with Social Security issues that arise, issues with Medicare that arise? Who can sign a contract on my behalf? Who can sign and deal with my tax returns with the IRS? These are all things that my property power of attorney can do for me. Now, I want to be clear, any assets that are owned by my trust, right? So I have a trust in place, and I've got my house or my condo in the trust, and I've got bank accounts and investments owned by the trust. My trustee will manage those things upon my incapacity, whereas my power of attorney for property will manage and deal with all of those other things that are not in the trust, right? IRA, 401k, those will not be in the trust. They'll be in my name, right? Signing contracts. Contracts have nothing to do with my trust, right? Signing a contract to move me into an assisted living facility, signing a contract to rent an apartment, etc. Now, again, I mentioned that a lot of times the order of trustees tend to match up with the order of executors that we name in a will. Well, those also tend to match up with the order of people that we name on a property power of attorney, because we're kind of thinking of who's the best at sort of managing my world, my non-healthcare world. And it doesn't necessarily have to be somebody that's really familiar with finances. People always say that. It's really not, right? Because I have a financial advisor. My power of attorney is going to step in and deal with my financial advisor. I have a CPA. My power of attorney is going to step in and deal with my CPA. I don't expect them to come in and start picking stocks. I don't expect them to come in and start filing my tax returns on their behalf, right? They're just going to come in and continue to work with all those people that I was already working with. So I always say it doesn't need to be your son, the financial advisor, or your daughter, the attorney. It needs to be that person who makes sure that bills get paid. And when the water heater breaks, they're on the phone with somebody, getting somebody out to the house to make sure it's being fixed, right? That's the kind of person we need to name. Who's good at running a household? That's really what I say. Who's good at running a household? Because if they're good at running their household, chances are they're going to be good at running yours. If they're not good at running theirs, they're probably not going to be good at running yours. Last thing is that the property power of attorney operates like the healthcare power of attorney. We can name as many people as we want, but it's one at a time in a particular order. Okay, the HIPAA. So the HIPAA is the healthcare authorization, right? Many of us have probably signed HIPAA before, whether at the hospital, at our doctor's office. Basically, who can have access to our medical information? That's really what a HIPAA is, right? Because once we all turned 18, I think we're all on this call, I think everybody's over the age of 18. Once we turned 18, we became the only person in the world that would have access, that has access to our medical information, unless we give permission. And so really the HIPAA, I'm going to be brief. The HIPAA really serves two purposes. Okay. First of all, three things. I can name as many people as I want on the HIPAA, and there's no particular order. So I can name Karen, Joan, Christy, Marguerite, Gloria, Anne. I know that's not Anne Raguzzi, but some relative of Anne. So I can name all five of them on my HIPAA, but there's no particular order. Any one of them can talk to my doctor or the nurses or the staff. If I was rushed to the hospital and there was an emergency and they wanted to find out what was going on, any one of them could communicate with the hospital or the staff at the hospital to find out what's going on. That to me is the most beneficial part of the HIPAA. It's really getting that access in a situation like that, and not having everybody on that I just named having to go through my wife to get the information from her, during a tough time. Okay, so anybody that's named on there can have access to the information. There is no decision-making authority though. That's the healthcare power of attorney. The HIPAA is strictly access to information. And the other thing that all 5 of you can do is you can all go to my doctor and ask for copies of my medical records at any point in time. So we got to be comfortable with that the people we're naming on there. Hey, if they really wanted to go to our doctor and ask for our medical records, they could. I'd like to think that most people don't care about that. Except for maybe those adult children that don't trust their parents relaying all the proper information to them, which I know is true of a lot of adult children. Yours truly included. The last document is the living will. So the living will is not like a last will and testament that we talked about earlier, right? This has nothing to do with who gets my stuff when I die. The living will is the do not keep me alive unnecessarily document, okay? It's not the same as a DNR, okay, which is now called a post. I'm not going to go into that, but it doesn't have the full force and effect of that. It's not like a paramedic looks at my living will and says, oh, Matt doesn't want to be resuscitated. It's not what a living will is. A living will is just more direction to my healthcare power of attorney that I do not want my life artificially prolonged, right? Do what you can to keep me comfortable, keep me safe. But if I really have no quality of life, don't just string me along. Okay, that's really what the living will is. It's just one more iota of evidence to my healthcare power of attorney as to how I feel about end of life care. So clearly for those clients that I work with that want their lives prolonged to the greatest extent possible, we don't sign a living will, right? A living will would not be an appropriate document for them, even though we, include it in our package, if you will. And on that note, it's 10:11. We got a few minutes, not all the time we have this. So I'll end there.
Unfortunately, I do have a hard stop at 10:15 because I have to host another Zoom call at 10:15, so I apologize. So I'll be quiet now. Quick questions. We've got 3 minutes. Unmute yourself, raise your hand, and Matt can call on you. Joe, unmute yourself. Space bar. Remember the space bar you can push? Yeah, there you go.
Okay, yeah, got it. Okay, this is me. I'm Joe's wife. How binding is a wish list attached to your trust?
What's on the wish list? Like items of personal property,
Well,
like I want my watch?
Anything that you put on there. How binding is that?
Well, I need more detail. There would be some things that, first of all, I would argue that very little would be binding. If you're talking about just attaching something to a document that was already created and signed, and you're attaching it after the fact, then it would likely not be binding at all.
Would it be binding if you're alive and you make out a wish list attached to your trust? Is that binding?
I think what we would be doing is if we're creating a trust or a will, we would want to make that a part of the document. There might be some cases where we could sort of create wording within the document to say that, yes, you can, there might be an addendum that's attached to this. And we do that sometimes with personal property. So sometimes we'll do that with clients where we create a trust and we have them, we say that within the trust that they can create a memorandum of personal property down the road as to I want my watch to go to my son. I want my wife's earrings to go to our daughter. That sort of list can be binding depending on the language that we then sort of relate to that list within the master document, if you will, within the trust or the will. But if we're just creating some kind of list, especially if it relates to money, it will not be binding.
Okay, and what is a subtrust?
A subtrust is like a trust that kind of springs out. So if within my trust, I want to say that, when I die, the money's going to go into trust for my kids or my grandkids. A subtrust would be like a little trust that gets created for them outside of internally within my trust.
And one last question for you. If you wanted, let's say you had a handicapped child and you had other children and you wanted half that estate to go to that child who might be fairly functional, is it better to put that in the trust, or just hope that the trustee will abide by your desires?
You'd want to create a separate type of set of trust for that child.
A subtrust?
Maybe a subtrust, maybe a separate trust in general. Might be a totally separate special needs trust. It would have to be, that's probably a bigger conversation.
Okay.
Yeah.
Thank you.
All right, and I'm sorry, everybody, thank you. But I have to stop because I have another meeting that starts right now. So thanks for joining us,
email's
everyone.
up there. Sorry.
Yep. So go ahead. Matt's information is up there if you want to reach him. Have a great day, everybody. Thank you. Take care. Thanks, Matt.
You're welcome. Have a great day, guys.
Bye, everybody. Thank you.